Good morning, and thank you very much. The most important thing for me to say to begin with is how difficult it is to express the sense of honour and privilege attached to this invitation to me. I'm really most grateful to be allowed to join you and to offer you what few comments I can. I'm also very sorry that I have only half an hour to spend with you, but let's hope it's half an hour that offers you something. I know that you would like some views on how the United Kingdom now appoints its judges. To make this work, it requires me first to explain to you what was, and now to explain to you what is. For many years, the Lord Chancellor, a party political appointment to government, and until fairly recent times, always a lawyer, headed a department which was responsible for appointing judges. The scheme upon which his department worked was that senior civil servants, not always lawyers, but trained in legal aspects, over an individual's career, and generally that individual would be a barrister, but not exclusively, would from a reasonably early stage in the individual's career begin to gather information and compile it into a dossier. It would involve asking questions of a wide range of office holders and individuals. For example, judges in front of whom the individual had appeared, leaders of the circuit in which he or she practiced, chairman of the Specialist Bar Association of which he or she was a member. So the Lord Chancellor's Department would have said, had you then been having a conversation with it, we spread our net widely, and our object is to gather a lot of information, but crucially, from a lot of people. We are doing this over a period of years, and we hope that it guards against twin dangers. One is that on a day when a spotlight was shone on the individual, he or she hit a purple patch and was on magnificent form and pulled off something of a coup. And on the other hand, that individual had somehow crossed an opinion holder who was unforgiving, and that unforgiving opinion infected the process. Those two, each for their own reasons, were undesirable. The Lord Chancellor would have said, that is guarded against, because it matters not to me whether Anne Rafferty hit a purple patch in August one year, because I can see from the other 92 opinions upon her that actually she's useless. Additionally, if it was obvious that Judge X had a poor opinion of Anne Rafferty, it would bear unpicking because every other judge and every other constituent contributor had a good opinion of her. So that was the thinking behind it. And eventually, if at all, an individual might be called in to the Lord Chancellor's Department and spoken to by the civil servants, either to see whether he or she were at that stage willing to accept an appointment, or at an earlier point, what his or her judicial thinking was looking ahead. I was called in twice during my career. Both times I was asked whether I had any judicial ambitions. Both times I told the truth, answer no. But I conceded on both occasions that I knew plenty of people whom I respected, who had had exactly that response and then suddenly changed. So I readily accepted that the time might come when I would suddenly change, as it did, and I gratefully accepted an appointment to the High Court bench in 2000. This was infelicitously called a tap on the shoulder. It was nothing like a tap on the shoulder. It was based on a good deal of work over years. Because I had a chum in the lower regions of the Lord Chancellor's Department, I happen to know that by the time consideration came to me for a full-time appointment, the paper dossier on me was 1.5 inches thick. Public mood changed. We are where we are. The phrase stuck. The tap on the shoulder was unattractive. Very few people sought to unpick it in the way I have tried to do for you. And in any event, political mores and mores generally were, as they tend to be, in a state of shift. So by 2005, we added to our statute book the Constitutional Reform Act. I'm going throughout this brief address, where I can, to avoid telling you anything unnecessary, and particularly to avoid telling you things which you could effortlessly look up on the internet and find out in 10 seconds flat. The Constitutional Reform Act changed radically the schema by which the judiciary was run. It spawned the 2006 creation of the Judicial Appointments Commission. And it is the Judicial Appointments Commission which features large in what I'm now going to explain to you, if I can. The JAC sits independently of government and of the judiciary. It answers to Parliament. It is made up of 15 commissioners, of whom 6 must be judicial, and that 6 reflects the hierarchy of the major judicial components of our system. The balance must be lay or professional, but not judicial. Importantly, as we shall see in a moment, its chairman cannot be a lawyer of any description. I had the enormous privilege of being its vice chairman until I retired in July this year. And they were 3 years of pure privilege, which I much enjoyed and from which I very much hope I profited. Right, the JAC, let us assume we're back in 2006, gets off to, on anybody's view, a bad start. For many years, it was seen widely as process-driven, rigid, both in its structures, but more importantly, in its approach, and far, far, far too layered. So the competitions it ran were seen as mirroring all those criticisms. It was an unhappy experience for many applying to it. Human nature never changes, so the fact that it was an embryo commission finding its way was very seldom deployed as mitigation for it. But no matter, the outcome was that it was not regarded with warmth or approbation. Compare and contrast what happened in 2016. That saw the arrival as its chairman, who, remember, cannot be a lawyer, of Professor Lord A.J. Kakar, a world-renowned vascular surgeon, professor of surgery at University College Hospital, London, and one of the driving forces behind the Thrombosis Research Institute. Elevated to the peerage in 2010 as a crossbench peer. A polymath of energy, determination, and charm. He started the process of elevating the JAC into a position where it was attracting deserved plaudits, underline deserved. He was not and is not interested in anything which is undeserved or unearned. His analysis, therefore, was to look at, top to bottom, the entirety of how the JAC functioned, look at the philosophy, look at the nuts and bolts, and see how it could be improved. One of the things, therefore, that I, if I may, would emphasize to you is that the JAC is self-examining at every stage of its processes. It has a group set up recently whose sole task is to see how anything could have been done better. It turns to psychologists. It has its own statisticians. The whole object of the exercise is to ban from its corporate thinking the word complacent. That is, in my view, paying dividends and has paid dividends. Since 2016, the JAC has begun to shed prolixity, to pare down the process by which any competition was run, to strike out anything which was not absolutely necessary, on the basis that the less people read and the less people hear, the more they will take in, and to make it clear to candidates that the JAC was there in large part to make sure a candidate could shine. So one, to me at least, important aspect of the way we run our system is that assurance, both clear and subtextual to a candidate. We want you to do your best. We will put ourselves at your service to enable you, insofar as principle allows, to do your best. We are your friend, and that is how you should see us. To that extent, and with that in mind, Lord Kakar set about changing the schema by which the Commission did its work. We have become, it has become, I've gone now, far more agile, far more understanding, and less inclined to say, but we've always done. Again, forgive me for intruding a piece of advice to you. I'm only here actually to offer you information, but I would like to trespass on your generosity to this extent. I would suggest any scheme set up now to help appoint judiciary needs to adopt that cast of mind. Are we the candidate's friend? Are we seen, on the other hand, as inimical to a candidate doing his or her best? It's a crucial question. And I think the JAC has done well, not just to keep posing it to itself, but to come up with some answers. And one can see that it is working because there is a constant iteration of evaluation and feedback, both from the successful and the unsuccessful, and the effects are very clearly made out. Our JAC operates from the very, very, very high volume competition to the top, where it is involved in, but does not technically run, competitions for elevation to the Court of Appeal. I can't tell you whether this major difference will affect anything you do, because I'm ashamed to say I don't know enough about your system, but lest it might, and in any event, because I want you to have a full understanding of the JAC, let me put a little bit of flesh on those bones. We recommend for appointment those who I would describe, and it is a compliment, as making up the boiler room of the administration of justice on the bench. They are the district judges, who are populated by people who have sat first as deputy district judges. They are the recorders or part-timers, I'll come to that in a moment, and the circuit bench. They make the system work at various levels. So let me tell you that in recent competitions, wanting to appoint the low number hundreds, we received 2,500 applications to sit as a deputy district judge. You have got to have some sort of scheme which makes that work. You cannot do 2,500 individual sifts and then thousands of interviews face to face. So we took a deep breath and we instituted things like an online test, which was designed to sift out, followed by a telephone interview, followed by another sift, followed by a face-to-face interview. There will be those who say it's not ideal. Well, I have yet to meet a system which is perfect. It has to be as good as it can be in the prevailing circumstances. It's not doing badly at all on the evaluation front. And it is crucial that at that level, our boiler room judges are the right appointments. Deputy district judges are fee paid. In other words, they're practitioners, so they will sit for a while per year and then go back into practice. That means that the system finds out whether it likes them, and they find out whether it likes the system. They feed the district judges. They are vital. They work enormously hard. They have little support in the sense of clerks and trappings. They're exposed. They have a good proportion of litigants in person whom they have to handle sensitively and appropriately. It's a tough job. It is a really tough job. Moving on through the ranks of those we look at for judicial appointments, I turn now to recorders. Now, these are solicitors or barristers who are quite often sitting in crime, but also will sit in civil and in family. I'm not too worried about the terminology. They would have a different terminology in family. Don't worry about it. I'm trying to give you broad strokes of the brush. So these are practitioners who want to understand either how judging sits with them, or, entirely legitimately in my view, to sit as a judge part-time so that they do their job at the bar or as a solicitor better. I'll settle for either. When I was made a recorder in 1991, I wanted both of those two things, and both of them worked for me. So a lot of applications to be a recorder. Same thing, you've got to have a system which allows you to get the job done. Then you will have thousands, just thousands of fee-paid members of the first tier of the tribunal system. They are crucial to how we run our lives. And they, of course, will not always, indeed quite often seldom are, lawyers. You get some tribunals, you have medical members, you have surveyor members. There's a challenge, making that work. So same thing, online testing, trying to meld two competitions which are pretty similar with each other for economy of purpose and economy of effort and some extra learning. And then you come up beyond the district judges to the circuit judges. There are the upper 400s of those nationwide. They will be doing the crime that you see on the telly. They're the ones that, in general, a member of the public, if you stopped them in the street and said, what does a judge do, would describe. From them, we go to senior circuit judges, which are exactly what they sound like, that level, but upper rank. They will be either leadership judges, so they're running a court, or they have extra responsibility. I'm going to the right-hand side of the page now. Remember, I told you about first-tier tribunal members. The first tier can be appealed to the upper tribunal. These are highly prized appointments. Upper tribunal judges can hold their heads up alongside the High Court bench. Then we have, coming to the top now of the hierarchy, appointments to the High Court bench. And that is where technically the Judicial Appointments Commission's controlled involvement ends. It plays a part, however, in appointments to the Court of Appeal. I'm going to put to one side a category called Deputy High Court Judge, which is particularly important to us, because I'm going to deal with that on its own in a moment. So let me remind you that we've gone from more than 2,500 applicants to be made Deputy District Judge. And for the High Court, we might get, as we have just, 52 applicants for 25 places and only 17 recommendations. Court of Appeal, 22 applicants, 13 interviewed, 8 appointed. So you can see what a vast range our JAC has to contemplate. It's a big organisation with a powerful chief executive and a strong set of staff. Now, the Deputy High Court Judge. This is a barrister or a solicitor who wants to do exactly what I described earlier, wants part-time to sit as a judge. Same thing. Do I like it? Does it like me? But increasingly, the JAC realised that this proving ground for the High Court bench was unsurpassed. The appointing panels of the JAC got maximum and valuable information from the sitting patterns and outcomes of the Deputy High Court judges, and it proved immensely valuable when appointing to the permanent High Court. So there was, I'm not quite sure what the phrase is, perhaps an underlining, perhaps a sharpening, perhaps a reinforcing outwards to the professions, that anyone wanting a permanent appointment to the High Court really needed to think about sitting first as a Deputy High Court Judge. That, in fact, was by and large already happening. But here's the important part, and that those sitting as a Deputy High Court Judge had to do so to sign up to their fixed term of years, 4 years extendable, on the undertaking that they were seriously considering applying to be a High Court Judge. We've come to the end of that first 4-year cycle, and we're halfway through the next, and it has paid dividends. Seen through any lens, at the end of that first 4 years, the appointments we made to the High Court bench were of the gold standard, and you would find no member of the profession to contradict that assertion, which is why I say it with such complete confidence. And I mention that to you, and it's why I've separated it out, because it's an important way in which we have thought at the JAC, and it's one of our major achievements. Finally, because I know I have to leave some time for you to discuss, and I will do my level best to answer any questions for you. I need to underline for you that in the United Kingdom, diversity in the appointment of judges is a statutory objective. The Lord Chief Justice must have it in mind. So too must the Judicial Appointments Commission. Alongside it, all appointments must be made on merit alone. Merit is, of course, easy to say and easy to articulate, and in many senses, easy to define. The position becomes a little more nuanced when it is set alongside the obligation to have an eye to diversity. To that end, and because everything the JAC does has to be capable of withstanding rigorous evaluation and intellectual scrutiny, Lord Kekar, with the full support of the commissioners, has taken 2 steps. First, he has taken over the chairmanship of the Judicial Diversity Forum. And within its folds, he has brought the governing elements of the profession. Therefore, when diversity statistics are published, the aim is that they will be published not seriatim or passim, but by one entity, the Judicial Diversity Forum, pulled together under one umbrella. The object being to give them potency. We understand increasingly as a nation, and certainly we do at the JAC, that diversity is very difficult accurately to define into a narrative. It's easy to say, well, you want people who represent all branches of society. Well, you do. But what do you do when some of them just haven't got the brain power? Some of them have previous convictions, some of them aren't interested, some of them feel disempowered by their personal circumstance. Some ethnicities behave differently from others. How do you understand that? How do you compare that ethnicity with this ethnicity and conjure your system to make each of them shine? There's a PhD in there somewhere, I am confident. So there is a lot of work to be done on it. The other thing that Lord Kakar has put in place is micro effect within the JAC. So we have begun to examine tools like blind sifting. I don't know whether your name is Anne Rafferty or Oba and Sube. Will it affect how your application goes? That's to be evaluated. Can you make it work? Answer, yes, more easily in some situations than others. If you ask medics who want to be appointed to a tribunal to undergo it, the medic who is sitting on the panel will effortlessly identify who it is, whether or not you give the name. But in other aspects, it might have more bite. In any event, the point is, it should be tried, and we're trying it. And secondly, and again, I don't know whether this will ever apply in your jurisdiction, we have within the JAC's commitments the equal merit provision. So if I apply and Oba and Subi applies for the same position, and after all the effort, the panel cannot distinguish between the two of us on any level, it can deploy, the Judicial Appointments Commission can deploy the equal merit provisions. It can look at Oba's ethnicity, my gender, and if either of us had a disability, it could look at that. So these things are stratified, they're nuanced, they have to be applied with attention to evaluation before they take the next step. But I want to underline to you, if I may, before I stop talking, that everything we've done at the JAC in the United Kingdom has been with the most benign of motives. And I would say with a noble proposition in mind, that the rule of law requires on the bench at any and at all levels, people of probity and ability and resilience and determination and independence. That's what we've tried in every single name we've recommended to identify and promote. That's what I wanted to say to you. I hope it's hit some spots, and thank you again very much for letting me speak to you.
Thank you.